Welcome, I'm Amy Jo Kinyon, and this is my First Amendment research case project for legal aspects of media class at Full Sail University. This is the case study of two very important Supreme Court trials concerning the media and First Amendment rights concerning libel and defamation. Let's take a quick look at the text of the First Amendment before diving into the facts of the cases. The First Amendment reads, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. Let's dive into our first case. The case of the New York Times versus Sullivan was a landmark case in defining how the First Amendment protects freedom of the press. The outcome of the case would have monumental consequences, no matter the verdict. Had the New York Times been found at fault, publications would have to fact-check almost every advertisement before it went to print for fear of being sued. Ads criticizing politicians and public figures would become almost non-existent. Editorial columns calling out misconduct or shedding light on any shady dealings by politicians would rarely be printed due to fear of the consequences. In 1964, in the midst of the civil rights movement, L.B. Sullivan was one of three men in charge of police in Montgomery, Alabama. Sullivan brought charges of libel against the New York Times for printing a full-page advertisement which he maintained, maligned his character, and attributed several acts to the police force he was in charge of, acts which never occurred. The printed ad did not mention Sullivan's name. However, Sullivan argued that the text implied that he was responsible for the actions, and any reasonable reader would be able to infer it was him they were referring to in the advertisement. Initially, the Alabama court sided with Sullivan, and the New York Times was ordered to pay $500,000. In an appeal of the case, the Times argued that maligning the character of Sullivan was never their intention, and that requiring the paper to fact-check every advertisement would infringe on the First Amendment and freedom of the press. The United States Supreme Court returned with a unanimous decision in favor of the New York Times, and permanently altering the landscape of publication. The court asserted that in order to prove libel, a public official must be able to prove that the publication acted with the intention of malice and knowledge that truth was not being accurately represented. In his concurring opinion, Justice Hugo Black wrote, I doubt that a country can live in freedom where its people can be made to suffer physically or financially for criticizing their government, its actions, or its officials. An unconditional right to say what one pleases about public affairs is what I consider to be the minimum guarantee of the First Amendment. Three main points came out of the Supreme Court's ruling. 1. Advertising is protected by the First Amendment. 2. Printed information, even if false, could qualify for protection from the First Amendment if the target is a public official. And 3. Malice against the public official must be present in order to win a libel lawsuit. In our next case, Chicago lawyer Elmer Gertz was the subject of an article in the magazine American Opinion. The magazine, published by Robert Welch, stated several false accusations concerning Gertz, who had been hired by the family of a young man who was shot and killed by Chicago policeman Richard Nuccio. In criminal court, Nuccio had already been convicted of second-degree murder. The article alleged that Gertz had helped to frame Nuccio and that he was part of a communist organization set to take down the local police force. The article also alleged that Nuccio had a lengthy criminal record and was a communist fronter. Gertz represented himself, and as these accusations were false. Gertz was a low-profile lawyer and therefore not considered a public figure. Some of those on the jury for the case did not even know whom Gertz was, making his status as a private citizen even more apparent. While Gertz was initially awarded $50,000, the decision was overturned on appeal, and Gertz took his case to the Supreme Court. 12 years after the initial lawsuit, Gertz was awarded $400,000 and outlined that private figures have to only prove negligence by a publisher, while public figures must prove actual malice. To avoid the lawsuit, Welch, who owned the magazine, could have easily fact-checked the information or printed a disclaimer. While it would have been hard to fact-check every single item, a quick check of any one of the items would have shown their lack of truth. According to the Digital Media lawsuit site, in Michigan there are several traits of a defamation claim may have. 1. A false and defamatory statement concerning the plaintiff. 2. An unprivileged publication to a third party. 3. Fault amounting to at least negligence on the part of the publisher. 4. Either actionability of the statement irrespective of special harm or the existence of actual harm by the publication. Law enforcement officials, municipal figures, along with owners and executives of prominent businesses, have all been considered public figures in Michigan. These two cases have had a profound effect on how publications are protected under the First Amendment. Due to the outcomes in these cases, public officials must prove actual malice took place, while private citizens must only prove negligence on the part of the publication. Had Sullivan been a private figure, I am sure the outcome of his case would have been very different. And the Gertz case can be cited as the reason that many publications now carry libel insurance as a way to protect their business in cases such as the one presented. Thank you for watching my presentation on the landmark cases of the New York Times versus Sullivan and Gertz versus Welch. Feel free to follow any of these links to find out more about the cases and how they have impacted the way publications do business.